arbitration is a private dispute resolution system that ends with a final and binding arbitral award. And what is most interesting about this final and binding aspect of arbitration is that national courts actually enforce arbitral awards, whether they are made in the same jurisdiction or whether they come from another jurisdiction, in a similar fashion as they would do for a final and binding court judgment from their highest level of courts. An important international legal instrument that is important to know as we understand this concept is the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards.
When we begin looking at the issue of evidence in international arbitration, a good starting point is to look at what the arbitration rules tell us. Now, let's pause here for a minute. Think about your own home country and think about what the proceedings generally are. If you have to go before a domestic court, you have to go to the High Court, the Supreme Court, and any other body. You would, in all likelihood, have a fairly detailed evidentiary code that spells out evidentiary principles, spells out rules on testimony, spells out rules on admissibility, right? If you don't have, a thick code, you are likely going to have case law. This would likely be more true for common law countries. But the idea is you have fairly well spelled out rules when it comes to evidence.
Today, we're going to discuss about a very interesting concept in arbitration. Yes, it's arbitrability. Before we start with arbitrability, I would like to give a basic idea about arbitration agreement. So what is an arbitration agreement? It is an agreement in writing to submit present differences to arbitration, which is called a submission agreement. Well,